How many of you have ever been sued as a trainer? So we have in this room about, what, 45 people? Collectively, we probably have a couple centuries of training experience, and only 2 in the entire room have ever faced a lawsuit. It doesn't happen very often, right? I mean, I think that's pretty clear. But the reason why I think this is important is that even though it's unlikely that you may come across a lawsuit, the potential for what it can do can be very bad. So really the purpose of my talk is not to talk about how to win a trial, because I hope you're not going to trial in these kinds of things. And it's not to talk about all these really complex legalese topics. What I want to do is give you tools that you can take today to try to protect your business if, God forbid, you ever end up getting sued in the future. So to begin then, I think it's only appropriate that we actually talk about what happens in a lawsuit, because if you haven't been through the process, you probably don't know. Let's go through what actually happens in a lawsuit. First, a complaint is filed. This is the initiating document. This is the thing that the plaintiff's attorney puts together and either mails to you or hires a sheriff or a process server to give to you. And they lay out the basis of their claim. Anywhere between 21 and 30 days, depending on the jurisdiction, you then have to file an answer. Sometimes you can file a motion to dismiss if you have a legal claim, like, for example, the statute of limitations ran or something like that. As a practical matter, we don't get to file motions to dismiss. But then you file your answer. Now, between the time of the complaint and the answer, that's when you're going to call your insurance company, which you better have. Your insurance company may or may not provide you a lawyer immediately. It depends on the specifics of your policy. They may or may not require you to do certain things between that time. It's really, this is a question of reading your policy and seeing what it says. One thing I will tell you is, do not talk to plaintiff's attorney without your lawyer approving it. Plaintiff's attorneys are not going to go away if you sweet talk them. And anything you say to them, they may use against you later. That whole, I invoke my Fifth Amendment right counsel, it does not apply in a civil case. They get to depose you and they get to put you on the stand. So after you file your answer, the court's going to set a schedule for the entire thing. And then we go through discovery. Now there are two main types of discovery. One is called written discovery. One of the things is called document requests. You basically ask the other side to give you documents that are relevant to the lawsuit. So for example, let's say you have a personal injury case through a training accident. Well, they might ask you, are there any waivers that the client signed? If so, please give those to me, and you have to turn it over. You might ask them, I need to see your client's medical records, because one of the issues is how badly is this guy injured. They have to give those to you. As long as the document's relevant, you probably have to turn it over. The only exception is certain types of privilege documents, like attorney-client privilege materials. There's also a tool called interrogatories. You give written questions to the other side, and they have to answer those questions under oath. So for example, list all people that to your knowledge know things about the case. You have to provide all those names and the contact information to them. The very last one are depositions. You've probably seen videos of these before. A deposition is a lot like a trial, or like trial testimony, except that there's no court. Both attorneys will meet in some room, usually at a law office. They'll have a witness, they'll have a court reporter who swears in the witness, go through the whole oath, and then both attorneys get to ask that witness questions. Why do you do depositions? Well, one, to learn facts in the case. Two, because you can impeach that witness at trial if they testify differently between the deposition and trial. And third, if for some reason the witness can't show up to trial, you can use the deposition transcript, or video depositions are becoming more common as well. So we've gone through all that discovery. That takes, as you probably can guess, that takes a long time to get through. Then you might have experts. In our case, you might have medical experts. And you might have experts on both sides of the case. They submit reports, and they get to be deposed too. Then we have a procedure called summary judgment. This is really the only time in the case where you can get rid of the entire matter without actually going to trial. Now the problem is it's hard. The standard is called lack of a genuine issue of material fact. What that basically means is, can a reasonable jury find for one of the parties? If there is a dispute in the evidence, if plaintiff has one story and you have another, and there's evidence to support both sides, a jury has to figure it out. The court cannot take that away from the jury. It doesn't matter if plaintiff is not a credible witness. Credibility is an issue for the jury. Then we go to trial, and that's the stuff you get to see on TV, but again, a real trial is far less interesting than the stuff you see on TV. And then if there's a judgment against you, then you go through collection. The reason why I'm going through this is all this stuff is expensive. You may have done nothing wrong, but to get to this point in the trial, for a small case, you're probably talking $40,000 to $50,000. That's for a small case. If, God forbid, your trainee is paralyzed, or if they died, you're talking a couple $100,000. Just to get the privilege of trying to demonstrate to 12 members of the public, or maybe 6, again, depending on the jurisdiction, that you did nothing wrong. So the question is, do we have a defense that can cut all this stuff out? Do we have a defense that says, it doesn't matter if I screwed up, they still don't have a claim? Is there a defense I can use where there's no genuine issue of material fact? There's something undisputed in the case that allows me to win. And the answer is, there kind of is. It's the written waiver, which we're going to talk about. Waiver is when the trainee releases all claims against you. Then you have assumption of risk. And that's where the trainee assumes a risk that is involved in the coaching services. But the difference is, a waiver is a complete release. An assumption of risk is, you knew what you were doing going in. They are related, but they are a little bit distinct, and I would strongly suggest putting both into a written waiver. Because let's assume that your waiver is invalid for whatever reason, you always have assumption of risk to fall back on, and vice versa. What we talk about going forward will not apply to the following states, because all these states have their own little rules. Louisiana and Montana both restrict what types of waivers you can do by statute. So, and frankly, they're pretty bad. It's not good to own a gym in one of those two states. Virginia, they have some really bad authority, and I think Danielle can talk to you about that, because I uncovered this while doing some work for her. But it turns out that there actually is a line of cases that are creating exceptions, so it's kind of unclear exactly where Virginia is right now. Connecticut, it's the same way. There's a lot of inconsistent case law. The general rule seems to be you can't do waivers. New York and Hawaii create exceptions for places of public recreation. You can't waive your own negligence for those. Now, New York has created a distinction between places of recreation and places of instruction. A lot of what we do is instruction, and so I think there's actually a pretty powerful defense for those of you who live and practice in New York. And I talk about that a bit in the article I wrote, which I'll refer you to. I'm not going to go into details right now because a lot of you aren't from New York. But I'm just going to point out that there is that distinction out there you might be able to use. So what are the basic principles for a waiver? What are the things that we need in order to make a waiver valid? Well, there are a whole lot of different things that depend on where you live and what the case law is. But I think they can be distilled down to three really basic things, what I would call the three deadly sins where waivers often go wrong in the case law. Number one is the waiver has to fairly cover the circumstances at issue. You have to specify who is covered, you have to specify what is covered, and you have to specify where it is covered. All three. Is it the gym's employees? Is it you? What? Is it training itself? Is it just using the facilities? Is it stuff that people do on their own? It depends on your business, frankly, but it's something to keep in mind. Where? Is it just in the facility itself? Is it the parking lot? What about for some of you all who own CrossFit gyms who run around in the neighborhood? Does it apply outside of even those two areas? Again, things to think about. And you have to have all three. The second one is, if you are going to waive your own negligence, you have to expressly state that in the waiver. And that makes a lot of sense, because as a matter of public policy, we don't want to encourage people to be careless. So if you're going to force your trainee to give up a right to sue you because you screwed up, we're going to have to require that it be pretty explicit. And this brings us to the third principle, which is another public policy principle. You can't waive intentional misconduct, right? We don't want a situation where I can punch a trainee and then when he sues me I say, but you signed a waiver. You can't waive intentional misconduct. Now, this is really easy for things like sexual harassment or assault, or your really kind of obvious intentional misconduct things that you don't think anybody should waive. But there is a kind of a blurry line between negligence and intentional conduct sometimes. And one of those is called willful blindness. If I negligently maintain a piece of gym equipment, let's say that I don't maintain my lat pull-down machine as well as I should have, and it breaks and injures somebody. Well, I could sign a waiver to protect me, or I could require a trainee to sign a waiver to protect me against that, because that's negligence. What if I knew there was a problem with it and didn't do anything about it? Is that negligence, or is that willful misconduct because I knew? What if I just decide I'm not going to maintain equipment at all? You want to come in and work out, that's fine, do it at your own risk, but I'm not going to do anything. Well, now we get to a little bit of a grayer area. Well, here's what the New Jersey Supreme Court said. Although it would be unreasonable to demand that a fitness center inspect every individual piece of equipment after every patron's use, it would be unreasonable and contrary to the public interest to condone willful blindness to problems that arise with the equipment. Thus, had a gym's management or employees been aware of a piece of defective exercise equipment and failed to remedy the condition or to warn adequately of the dangerous condition, or if it had dangerously or improperly maintained equipment, the gym could not exculpate itself from such reckless or gross negligence. If you negligently maintain equipment, you should be able to waive it. And that's exactly what the court held, by the way. In that case, it was negligently maintained equipment. The waiver was effective. But if you don't maintain it all, or if you know of a problem and don't warn about it, now we're into willfulness, and you can't waive that. So I see three problems with this one. So who thinks they know a problem with it? No explicit mention of negligence, right? Okay, so there's one. Yeah?
No mention of location, the where part.
No mention of location. And actually, it goes a little further. There's a bigger problem than that even, but it's related to what you said. What happens if I sue the gym? Oops. Somebody forgot to put something in there. This is an actual waiver from a New Jersey case called Bailey v. Palladino. I cited in the article. But this is an actual waiver, and those are the two things that they mentioned. They said there's not a waiver of negligence, and the lawsuit was against the gym. And the court even acknowledged this is probably a drafting oversight. They probably intended to waive the gym's liability too, but they didn't. So we're stuck with the language we've got. There's one more, though. And if you're not a lawyer, there is no way this would ever occur to you because it is such common sense that only a really nitpicky person would not believe it's there. What if the trainee dies? There are a handful of states out there that will narrowly construe waiver clauses. Their law actually says, in the case law, we are going to strictly construe all waiver clauses. And this is not just merely academic. In 1991, Alaska, which is such a state, their Supreme Court held that a waiver that waived injury did not preclude a wrongful death action. Because it only waived injury, it didn't waive death. So, here are the changes I would recommend making. We add the gem, we add death, we add an express negligence waiver for our own negligence. So, what are the issues of this one? You know, obviously they're not lawyers. It talks about injury and it doesn't say what the injury is. What is the trainee assuming the risk of here, right? I mean, if you read this, would you have any idea what you're waiving? You know, I don't think so. The waiver says that the trainer advised that participation could result in physical injury, but doesn't say what the trainer actually advised. The plaintiff can say whatever the hell they want. And there's no way that you can come back and deny it, because it doesn't say what you actually advised. I think this actually opens you up to not being able to do summary judgment, because you might have a credibility dispute. The plaintiff may say one thing, you may say another as to what you told them. Now, this is not a complete list, but these are, I think, some of the bigger ones. It could result, trainer has advised me that such participation could result in serious injury or death, including broken bones, strained or torn muscles, ligaments or tendons, herniated discs, cardiovascular or cerebrovascular events, including heart attack and stroke, and injuries due to overexertion, including our friend Rhabdo. So I think that's a way that we could say specifically in the agreement what they've been advised on, and now they can't contest that. If they come back and say, well, I wasn't told it could lead to stroke, well, yeah, you were. It says in the agreement that you signed. So now the next one. This one should look familiar. It is very humorous. And if you are a member of Wichita Falls Athletic Club, you have to sign it. I'll let you take a look. I love that waiver. We don't do anything. That's what the waiver says. We could actually shorten it just to we don't do anything. But let's try again. Now, I'm not going to criticize the element of, maybe somebody could argue this is too humorous to be taken seriously. I know that argument's out there. I frankly haven't looked at that issue, so I don't know if that's a valid critique or not. But, putting all that aside, let's just go back to our three principles. And frankly, back to the whole waiver versus assumption of risk idea. What are the problems with this one? Yep. Willful blindness and intentional. Actually, it goes even further than that. We won't even try to warn you about a dangerous or hazardous condition, whether we know about it or not. Even if they know it, they're not going to tell you. Okay, so definitely I think that's one of the big problems. And actually, there's a related problem as well, just from a lawyer's perspective, because I always try to think about scoring points. Let's say that a piece of equipment in this club did fail, and their argument was that it was Wichita Falls Athletic Club was willfully not maintaining their equipment. What do you think Exhibit A is going to be to the jury? They told us they don't maintain it. Right? And it's not going to go well in a deposition either. Are you saying you never maintain your equipment? Well, no, we do. Oh, well, then why did you say you don't? Or alternatively, well, no, we don't. Okay, well, I've got you on willful blindness. It doesn't turn out well either way, right? So I think there's actually an evidentiary problem with this as well. I think that it can actually make a plaintiff's case where it might not otherwise be there. One other thing, though. There's one other big thing I see. You'll notice if you read it, there's actually not a waiver section anywhere in the entire agreement. It is all assumption of risk. So I think that's a potential issue, that if the assumption of risk is thrown out, there's a problem. And there's one more issue too, and it goes back to the willfulness problem. Sometimes courts, if they find that if they find a piece of the waiver is invalid, will throw out the entire waiver. So even if, now there's a way that we can protect against that, which I'll talk about later. But sometimes courts will do that. They'll say, well, you're trying to waive willfulness. You're not allowed to do that. The whole thing's out. Hope your insurance coverage is up to date. So how would I fix that? Well, I confess, I just kind of drafted a new one. We're being a little bit more specific. We're getting to the exact same aim, but we're doing it without talking about willfulness. And in fact, we expressly have a waiver for negligence in there. I hereby waive, release, and discharge WFAC and its officers, agents, or employees from any and all liability from injuries or damages. Probably should have added death, but I don't think Texas is that narrow, actually. Arising from or any way connected with use of training and fitness equipment, platform, structures, and machinery. I think we get there with this. Now, again, I haven't done a deep dive on Texas law, usual caveats, CYA stuff, but I think this gets us there without running into potential issues.